Our next category, what if it settles? We always try to settle our cases, right? Settle them if you can and get a good result for your client and not put these clients through the expense, emotional and financial of a hearing. So we try to settle. I believe in settling, but I'm only going to settle if I can get what I think is an acceptable deal to my client and my client agrees. Well, if we do settle, there's still steps to be taken. So one is you need to get a signed Rule 11 or order. No oral settlement, that's not real. You need a signed Rule 11 or order that you can enter with the court before you cancel your hearing so that you don't get tricked by a tricky lawyer. They have actually signed something. So I get that signed and filed with the court. And then you need to call as a courtesy to the court, the coordinator, and remove the hearing. Just because you entered a settlement, it seems like they know we're not coming because we entered a settlement. But the left hand and the right hand at the court do not know what the other one is doing. So just because you've entered an order, they have many, many cases, they're not aware of that. So you need to individually email or call the coordinator and say, hey, we've settled, we will not be there. And that's a courtesy because the judge is trying to balance their docket and have enough cases to have something to do that day, but not so many that they can't get to them. So if you let them know, that helps their docket. And then the last one is you want to send a file marked copy of the Rule 11 or judge signed order to opposing counsel. So if you're the one that filed it, once it's has its file stamp or the judge's signature, depending on which one it is, the Rule 11 or the order, you want to send that to the other side and to your client, of course. Okay, our next category is your proposed order. So we talked about that you definitely want to bring a proposed order, and I like certain things in my order, and you probably like other things in your order. So you can start out with my list and add to it the things that you like. So one is, I like to have the paragraphs numbered, and if you use ProDoc, which I do, and it's a great starting point, it does not number the paragraphs. And I know that just sounds like something about the beauty of my order, but that's not the reason I like it. The reason I like it is we might be talking about that order in the future, in a hearing on a motion to enforce, or in a future hearing where we're trying to compel someone to do something, or we're at final trial. And if we're referring to that order, it's a lot handier to be able to say, look at paragraph 3. In paragraph 3, it says blah, 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 than if you have no numbering. So, for a very practical reason, I like it to be numbered. Then, at a temporary hearing level, I would not include the outside 100-mile language because they aren't even supposed to leave the county without permission or agreement while we're at a temporary hearing level. So, why submit a possession schedule that has outside 100-mile language, unless they already live outside 100 miles for some reason? That would be an unusual circumstance.